Remember, there's another trial, too.
All right, present before the court at this time is the state of Ohio. It's represented by Prosecuting Attorney Nicholas Irochi. Chief Assistant Prosecutor Cecilia Cooper is also present. The defendant, Edward A. Smith, is present. He's accompanied by both of his attorneys, Gregory W. Myers and Marie Lane. The jury began their deliberations this morning at approximately 8:30 when they were advised to return, and they have been deliberating since that time, and the court's been advised by the bailiff that they have reached a verdict. So I'm going to call the jury into the courtroom here in just a moment. We're going to receive the verdict. There's nobody in this room right now, including me, that knows what this verdict is. And whatever it is, I don't expect any outbursts or anybody acting up in this courtroom. If you do, you may be found in contempt of court. I've already talked about that last week. So I expect you to all to act as responsible adults. All right, call the jury back.
Please rise to the jury.
You may be seated. Let the record show the jury has now been returned to the courtroom. All members are present and accounted for. I believe yesterday it was the foreman of this jury was identified, and I believe that is juror number 5, Clifford Barnes, is the foreperson. Would you please hand the verdict form and any other documents you have to the bailiff? Where are the exhibits? Are they still in the jury room? Okay, and the copies of the instructions that were given to you, they're also in the jury room? Yes. Okay, all right, will the bailiff all right, the verdict appears to be in proper order, and I'm going to hand it to the bailiff and ask her to please read it into the record.
In the matter of the state of Ohio versus Edward A. Smith, indictment for murder, 2 counts, revised code 2903.02, under count 1. We, the jury in this case, being duly impaneled and sworn, find the defendant, Edward A. Smith, guilty.
Whoa!
All right, take her out.
We, the jury, do find beyond a reasonable doubt that the defendant, Edward A. Smith, while committing murder, had a firearm on or about his person or under his control, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used the firearm to facilitate the offense.
At this time, the court would like to thank the jury for the time last week when we started this case. We were pretty not too definite on how long it was going to take. I think the estimate was anywhere from a week and a half to 2 weeks. The court notes you were all here in a timely fashion, and if you wish to discuss this case with anyone, you may do so. You are not required to talk to anybody about this case. If you should be approached by anyone, the news media, the attorneys, spectators, anybody else, and you prefer not to discuss it, just tell them you don't care to discuss it, and that should end the conversation, because you're not required to do so. So, once again, with the thanks of the court, I'm going to excuse you at this time. There are the deputy sheriffs that will escort you either out to your cars or down to the sheriff's or down to the clerk's office and then eventually to your cars. So go with them and they'll see that there's nobody that tries to approach you if you don't want to be approached. Okay, anything else from council concerning the jury?
No, Your Honor.
No. Very well, thank you very much.
I want no picture.
The offenses are demeaning to the seriousness of the offense and do not adequately protect the public from future crime or punish the defendant. The penalties that are available under the statutes for conviction of murder are life imprisonment. I don't know how this court could ever say that sentence is demeaning and not adequate. The offenses are demeaning to the seriousness of the offense and do not adequately protect the public from future crime or punish the defendant. The penalties that are available under the statutes for conviction of murder are life imprisonment. I don't know how this court could ever say that sentence is demeaning and not adequate.
Pac-Man and Rainey, they were not innocent. They engaged in a lifestyle of bringing heavy quantities of drugs into this county. Pac-Man was bringing 8 to 10 ounces of cocaine in here. The investigation revealed that Rainey was supplying the county with the molly. They were not innocent. They engaged in an activity, as the appellate courts have held, is
I
inherently.
would like to thank law enforcement, Judge Benham, prosecutor, the jury, for all the time and effort that was given to this case. Your services will be greatly appreciated by the Dowdell and Rainey family. The night of November 25th, 2013 was the worst and biggest tragedy of our life. Let me start off by saying, Elliot will be truly missed by his family members and also his friends. Next, I would like to take a moment to express the life of Elliot and what he meant to our family. Elliot was the youngest of 4 and was 9 years younger than me. I helped raise him along with my grandmother after our mom passed away. When Elliot would walk into a room, his bright smile and sense of humor would brighten everyone's day. He would always help anyone in need. Even though he was the youngest, he was the mentor of our family. He was always the one to tell us to keep calm and to keep control of all situations. His kind heart was always shown with his mom, father, sister, brother, children's, nieces, nephews, uncles, grandma, and etc. His biggest downfall was that he was too trustworthy, thinking that everyone was his friend. Elliot will truly be missed by me and my family. We have no idea why Elliot and DeAndre's life was taken so sudden or so soon. We will never have the chance to see our loved ones again. Knowing that you will be judged by a greater power in the end is worthy enough for me. Words from DeAndre's mom that's not able to be here. My son was not just taken from me, but also from his father, children, siblings, grandma, and we are not able to see our loved ones. DeAndre, again, even though the defendant is able to see his family, we will never be able to see beloved DeAndre again. He will still have life, and we will be without life. We, the family, ask that the sentence for Mr. Edward Smith be the maximum as law allows. Thank you.
But the court has considered the evidence in this case. I am aware of the prior convictions that the defendant has. I wasn't aware of the December 2012 possession of drug conviction in Cuyahoga County, but the failure to comply, the felonious assault with weapons under disability that occurred in Ashtabula County, and or conveyance of weapons into a safety zone. I was certainly aware of those that were on the record. Conduct is always considered more serious if it meets one of certain factors that are set forth in section 2912, under subsection B. I'm not gonna read all these factors, but there are a couple I think that would apply to this case, and I'll just comment on them quickly. One of the first factors is the physical or mental injury suffered by the victim of the offense due to the conduct of the offender and the nature of the injury. Quite frankly, most of these factors in the statute I don't think have any application. One factor is whether the victims induced or facilitated the offense. You know, it's hard to, nobody knows exactly what was said and what went on in that kitchen the evening of November 26th, but it's hard to believe that anything happened in there that would justify taking the lives of the victims. So that wouldn't apply. Whether the offender was under any provocation, there are substantial grounds to mitigate the offender's conduct. I don't find any grounds to mitigate his conduct that have been shown here. There's other factors here on recidivism that the court's to consider. This is in the same statute, 2929.12, under section D. The court can find that the offender is likely to commit future crimes if it makes some of the following findings. Whether the offender has been rehabilitated, having previously been adjudicated either a delinquent, or whether he responded to sanctions previously imposed for criminal convictions. I'm not sure just what sanctions may have been imposed on those prior convictions, but it seems that it's getting worse. He's going from not complying with officers' orders, conveying weapons into school zones, drug possession. Now we got 2 murder convictions. So he certainly hasn't rehabilitated based on his prior convictions. Lastly, whether the offender is not likely to commit future crimes, the court can consider whether he's not been convicted of prior crimes. That's not true. Whether these offenses were committed under circumstances not likely to recur, as long as they're buying and selling drugs, these circumstances can occur frequently. And lastly, whether the offender has shown any remorse for his actions. I haven't seen any demonstration of any remorse so far, for whatever that's worth. That's probably the least important factors. But to make a conclusion here, the court would conclude that the seriousness factors override the less serious factors, and recidivism is more likely than not. Nobody has the right to extinguish a life, and I think by ordering a concurrent or together sentencing, in effect, the defendant gets a freebie here. I don't think you're entitled to a freebie. You killed 2 people. And, you know, after listening to the evidence in this case, I can see why you might have been mad at Pac-Man. I don't know why you shot Mr. Ramey. It looks like he was just in there by chance. He wasn't called in or invited, and certainly didn't come with Pac-Man down to that meeting at Hall. So the court finds that consecutive sentences in this case are necessary to protect the public from future crime and to punish the offender. The court also finds that consecutive sentences are not disproportionate. When he had that felonious assault conviction in Cleveland, beyond that point he was prohibited from ever obtaining, using, acquiring firearms, and he's done it continuously. You can see he's been convicted again, I think that was in 06, of having weapons under disability, and he's not been rehabilitated to any extent, in my opinion. So, the court also finds lastly that the history of the criminal conduct requires consecutive sentences, and it's necessary to protect the public from future crime. The defendant has not demonstrated any respect at all for human life. I don't know how you can get that mad over people and drugs that you want to kill people, and it's a shame that this society has been degraded to that extent. And also, consecutive sentences are necessary to protect the public and to reflect the seriousness of your conduct. So the court is going to impose consecutive sentences. If I did not, there would be in effect no sentence for one of these killings, and the court cannot on that. If you're gonna kill multiple people, there's multiple penalties that are gonna be imposed. So, it's a judgment sentence of the court, after considering all the evidence in this case, the arguments of counsel, have considered the recidivism and the seriousness factors. And, court orders that under count 1 of the indictment for conviction of murder, that the defendant be sentenced to the Lorraine Correctional Institution in Grafton, Ohio for a definite period of 15 years to life. The court is not going to impose any monetary fine. I didn't hear anything in this case that indicated he had any access to any funds or property that he could pay a fine with. He's going to be incarcerated for a substantial period, and I don't see any ability to pay a fine. Also, I'm not going to order any restitution. It's a vain act. You'll never get a dime from this defendant. He doesn't have it. Now, the defendant's entitled to a jail credit. I've computed, I believe he's been in jail 506 days. That includes all the days from November 26th, I believe, is the day he was arrested, until today's date. So we'll give him a jail credit of 506 days. And he's also sentenced on the gun specification to a mandatory 3-year prison sentence. And that will be served first before he begins the 15-year to life sentence. Now, on count 2, it's ordered that the defendant be sentenced to the Lorraine Correctional Institution in Grafton, Ohio for a definite period, an indefinite period of 15 years to life. It's ordered that that second sentence on count 2 be served consecutive to the sentence imposed on count 1. Now, the defendant's entitled to a jail credit. I've computed, I believe he's been in jail 506 days. That includes all the days from November 26th, I believe, is the day he was arrested, until today's date. So we'll give him a jail credit of 506 days. And he's also sentenced on the gun specification to a mandatory 3-year prison sentence. And that will be served first before he begins the 15-year to life sentence. Now, on count 2, it's ordered that the defendant be sentenced to the Lorraine Correctional Institution in Grafton, Ohio for a definite period, an indefinite period of 15 years to life. It's ordered that that second sentence on count 2 be served consecutive to the sentence imposed on count 1. You have the right to appeal this case without the payment of court costs if you're unable to pay the costs of an appeal. You were found to be indigent at the time you were first indicted. You've been in jail since that time of your arrest, so the court would presume you're probably still indigent. Nobody connected with the defense thinks I'm appointing some attorney that's going to be friendly to me and not raise any issues of any errors I might have made. It's somebody that's independent, somebody that I haven't appointed. The Court of Appeals has done this in the past, and I will appoint, I'm going to appoint Marie Lane. All right, one thing I'm going to order a post-sentencing report. Often we get these reports prior to sentencing. I've already indicated that the penalties in this case are automatic. They're set by statute. I don't have any discretion in giving more or less than I've given. But sometimes it's nice, you don't know what the future's going to hold, what motions might be filed, what the appeal court might do with it, and if for any reason they ever needed a PSI for maybe another, if I've made a mistake here today, you could have another resentencing down the road, PSI would be helpful. So I'm going to order the probation department to go over and talk to Mr. Smith before he's transported, and I'm going to have them file a post-judgment or post-sentence report. It will be filed with the court. It will be available for future use if anybody, including the defendant, needs to, or they've already terminated bond in this case, and I'm going to remand the defendant to the custody of the Ashtabula County Sheriff's Department for transportation forthwith to the Lorraine Correctional Institution in Grafton, Ohio. Now, I ask council, is there anything I've overlooked? Is there anything that I have not covered? If so, please give the court some assistance.
No, Your Honor.
No, sir.
Very well.
Let's go.
It's the point if we go out here and they do something and we fuck one of them up and y'all come arrest us quick.
Jackie,